Aloha, assalamu alaikum. Thank you all so much for being here today. My name is Salma Rizvi. I'm the Executive Director of the ACLU of Hawaii. Thank you for so much of my staff being here today, as well as Professor Manisha Dasgupta, who's on our Board of Directors. Thank you so much. A few weeks ago, we were approached by a number of student activists who came to our offices requesting that the ACLU provide support in this great historical moment that we're witnessing. The ACLU is a nonpartisan entity, and we don't take stands on international issues, but we do continue to support the religious freedoms, as well as the civil liberties freedoms and the rights to free speech and freedom of assembly. And so whatever we can do to help those who are dissenting and protesting in this moment, we support you in this way, and we're happy that you're using your voices to raise the American conscious. So thank you so much for all the work that you all are doing. And one thing that was requested was some more information about the freedom of speech, particularly in the school setting. And so we're lucky today to have our acting legal director, Taylor Bragg, presenting for us. And she's a beautiful, shining star, young woman of color. I'm so blessed to have her on our staff. And I'll just say a few words about Taylor. Taylor was born and raised on the Mississippi Gulf Coast, and she graduated from the University of Mississippi in 2015. Then she moved to Oahu in 2016, where she graduated from this law school, Richardson School of Law, and was admitted to practice in 2019. She spent 2 years as a post-grad legal fellow at the Refugee and Immigration Law Clinic, and the clinic was established to ensure that Hawaii's most vulnerable immigrants would have access to legal services. She practiced removal defense in immigration court and assisted clients in their affirmative applications for visas, legal permanent residency, and naturalization. She primarily served asylum seekers, DACA recipients, unaccompanied minors, and others in need of pro bono legal immigration services. She also clerked at the family court for 1 year, and she was a clerk for the senior family court judge, Honorable Matthew Viola. She joined the ACLU family as a staff attorney in September 2022, and she's just done so much in this role in the last, less than 2 years. It's been amazing to see her in just the last 3 months, how much she's done and stepping up for our legal director, who is on paternity leave right now. So thank you, Taylor, for all your work. Some of the things that she's done at the ACLU of Hawaii includes assisting in several pieces of impact litigation, covering different areas, including Title IX discrimination in school athletic programs, police misconduct, racial and disability discrimination in schools, access to reproductive health care, pretrial bail reform, and the constitutional rights of houseless people being targeted by the government, which I know her and our paralegal George, as well as our legal fellow Samantha, who are here, that they've all endured a lot, and all of the dilemmas that come with impact litigating and helping and finding clients and accessing clients. And so this work is uniquely challenging, and I'm so proud of Taylor and her team for doing this work. She's currently filling in again as legal director while Wookie's on leave, so please give her a big round of applause as she walks us through.
Hello everyone, thank you for coming. We're going to talk about free speech for students today. So, as has been previously mentioned, I'm an attorney at the American Civil Liberties Union. It's a nonprofit, nonpartisan national organization devoted to the protection of civil liberties. This is an old organization. It was established in 1920. The ACLU of Hawaii was established in 1965, and we're part of the larger national organization. I want to give you a little bit of background, talk a little bit about where we stand as the ACLU. So as you are all aware, tensions are high between Israel and Palestine, and that is a conflict that is erupting on a lot of different forums, a lot of different spaces, and one of those is the university. And it was brought to the attention of the ACLU that there was infringement of free speech rights, and our response to that was to issue an open letter to the leaders of colleges and universities. And I'd like to share with you some of what that letter said. So in the letter, and this is authored by the leaders of the ACLU, we strongly oppose efforts to stifle free speech, free association, and academic freedom here at home. In the name of those principles, we urge you, university leaders, to reject calls to investigate, disband, or penalize student groups on the basis of their exercise of free speech rights. The experience of our country's universities during the McCarthy era demonstrates that ideologically motivated efforts to police speech on campus destroy the foundation on which academic communities are built. Such investigations chill speech, foster an atmosphere of mutual suspicion, and betray the spirit of free inquiry, which is based on the power to persuade rather than the power to punish. So this is what was happening in this particular instance. You had organizations like the Anti-Defamation League and the Louis D. Brandeis Center for Human Rights, and they called upon universities to engage in these widespread investigations against student groups who were speaking out in support of Palestine. And their basis for this, they didn't have actual evidentiary support for these claims, but they asserted that certain student groups, pro-Palestine student groups, are providing material support to Hamas, and which would put them afoul of certain federal regulations that prohibit the material support to terrorism. So it's a pretty serious allegation, and what they were trying to do is to chill the speech of pro-Palestinian student groups. And so in response, the ACLU reminded our university communities around the country that it's their responsibility to protect free speech and to not engage in the kinds of investigations that they were calling for. Before I get into the specifics of what the law says, I want to give a brief disclaimer. I am an attorney, but I'm not your attorney, and you will hear me share a lot of general legal information, but it is not legal advice. And if you have a specific legal matter where you're looking for legal advice, you should consult your attorney. Okay, so free speech, what does that mean? It's a pretty broad topic. I want to point out that there's two primary legal authorities that give us the right to free speech, and that's coming from the United States Constitution, and it's also coming from the Constitution of the State of Hawaii. As you look at the two snippets, you'll notice that they're very, very similar in their language, right? And both of them prohibit the enforcement of laws that abridge the freedom of speech. So freedom of speech, what exactly does that mean? What's important to know is that when you're talking about exercising speech here at the University of Hawaii, the University of Hawaii is a public institution, federally funded. And so, just like the government, the university cannot infringe upon the right to free speech. And I want to spend a lot of time looking at the specific guidelines. So, up on the screen now is the Executive Policy 10.206. And this is the university's policy on free expression on university campuses. You may or may not be familiar with this. I want to point this out to you because whenever there's a question about what your free speech rights are, whenever you're engaging in dialogue with the administration, this is the first place you want to refer to. You want to look at the guidelines. And you'll notice that these policies were written with the constitutional rights in mind. So that's where all of this comes from, and the specific language in the policy is what you want to look at. So this policy suggests that this university is one that values free speech, academic freedom, and all of the wonderful things that flow therefrom. Let's take a closer look at what that looks like in practice. So yes, they do support free speech, but while they are sort of encouraging and supporting and promoting free speech, universities have the ability to enforce content neutral restrictions on speech. What these restrictions look like primarily is restrictions that regulate the time that speech is taking place, the place where it's taking place, and the manner. So these are time, place, and manner restrictions. These are permissible under the Constitution. And the reason why the university is allowed to impose time, place, and manner restrictions is to, quote, assure the orderly conduct and least interference with the university responsibilities as a public institution for higher education and scholarly inquiry. So whenever the university is trying to impose these time, place, and manner restrictions, there's a couple things that you should know. They're doing it for imposing order, and whenever they are imposing a requirement, it has to be the least restrictive requirement. I'll talk a little bit more about what that looks like. So, it's a balancing, right? And it's tricky. A lot of universities around the country struggle with this. This language comes directly from your free expression policy. So on the one hand, campuses will permit non-commercial student speech and assembly in all areas generally available to students and the community, without first having to obtain permission from the chancellor. These general available areas include open areas, sideways, walkways, or internal streets, or other similar common areas. So that is a right that the university is making very explicit. In any of those public areas, you can go, you can exercise your free speech. You don't have to seek permission from the chancellor. On the other hand, when it comes time to look at time, place, and manner restrictions, the university is required to only impose restrictions that are neutral as to particular viewpoint expressed and applied even-handedly to all similarly situated parties. These guidelines must be narrowly tailored and not substantially burden the expressive activity more than reasonably necessary. And also in that policy is the requirement that these guidelines must leave open ample alternative channels of communication. So again, these restrictions have to be content neutral. They can, the university cannot say to their students, we don't want you to express a certain opinion or a viewpoint because that's not content neutral. That's looking at the substance of your speech. That's not allowed. Also, if they are going to impose a restriction, it has to be imposed equally across all the different speakers on the in the university community. And these guidelines must be narrowly tailored and not substantially burden the expressive activity. So when we talk about least restrictive sort of regulation, whenever the university is saying, oh, you can't do that at this time, you can't do that in this place, it's a fair question to ask, well, where can I do it, right? So the burden is on the universities. If they're going to impose this regulation, this restriction, they have to keep open channels available somewhere else, right? If they say, oh, this classroom is not the place for you to say that, then it's fair to ask, well, where can I say it? And they should be able to answer you. And again, the universities, whenever they do impose restrictions, the rationale for that is the campus is trying to further their interest in the orderly function as an educational and research public institution. That is a bit vague, right? What's one person's order? That reasonable people can disagree on what's orderly, right? So that's kind of the sort of gray area, and we'll talk a bit more about what that looks like in practice, but they have the power to do that under certain circumstances, but it's a very narrow power, and that's where a lot of the conflict comes from. So in general terms, when we look at what universities can and cannot do and regulating free speech, there's a couple things to keep in mind. So again, time, place, manner restrictions. One example is banning loudspeakers in certain areas of campus to prevent classes from being disrupted. That is a ban that is permissible under the First Amendment. The universities can also prohibit free speech activities that block the flow of traffic and pedestrians on campus. So yes, you can occupy the open areas, you can exercise your free speech, but if it gets to the point where traffic is impeded or pedestrians are not able to pass by, then you can expect the university to say something, and they're allowed to under the First Amendment. The universities can also ban free speech activities in areas that are normally not open to the public, right? So if you are occupying somebody's office, if you're in the areas of campus that are reserved for maintenance, know that the university can punish you for that. Sometimes there are situations where that is the goal. You want to occupy the chancellor's office because you know it's breaking the law, you know it's disruptive, and you accept the consequences for that. But that's not something that the First Amendment permits. Universities can also designate certain areas on campus as public forums where free speech activities can take place. So in your specific UH policy, they do mention bulletin boards. And I know I've seen them as well on Upper Campus. Those are supposed to be spaces for free speech if you want to advertise things, student lounges, certain places universities can designate. This is the free speech forum. And so it's a good thing to pay attention to. If you're telling me, oh, I can't do it here, well, where can I? And the university has to answer that question. Universities can also protect students from bullying, harassment, and threats. There's a lot that we can say about that, and there's more policies that dig deeper into all the kinds of harassment and threats and how that's regulated. We'll talk more in detail about that. So generally, with all of these time, place, manner restrictions, again, the idea is that the university is trying to prevent any activities that materially disrupt classwork or involve substantial disorder or invasion of the rights of others. So that's where the line is. Is it introducing a whole lot of disorder that disrupts what the university is trying to do? Is it invading the rights of others? That's where the line is. Universities cannot enforce a total ban on free speech activities in public areas. So if they have these public forums and they shut them down, that's not allowed under the First Amendment. The universities cannot restrict free speech activities of a specific group or individual while permitting others to have unrestricted freedom. So that's the whole idea, that restrictions have to be imposed evenly. They can't favor some groups at the expense of others. Universities cannot punish, prevent, or retaliate against a student for expressing a certain viewpoint during class. So one example that comes to mind is you are sitting in class and you have a t-shirt that has a slogan on it. And perhaps it's offensive, perhaps the professor doesn't care for what you're expressing on your t-shirt. Even if that's the case, even if it's offensive, it's not something that the professor can punish you for, right? And First Amendment retaliation claims, they're a little tricky. In order to prove that you are being retaliated against as a student, you have to show three things: that you are engaged in protected conduct. So I'm exercising my free speech rights, and at the time, you also have to prove that an adverse action was taken against you that would deter a person of ordinary firmness from continuing to engage in that speech or conduct. So what does that mean? An adverse action. What did the professor do? Did they call you out? Did they ding your grade? How did they harm you? And is the harm that you suffered such that a person of reasonable firmness would feel intimidated, right? And thirdly, you also have to prove that there's a cause and effect relationship between the two elements. In other words, you have to show that the adverse action taken against you as a student was motivated, at least in part, by your protected activity. So it's tricky if you think about it. If you're in a classroom and you're wearing a shirt and the professor, you really get under the professor's skin and you start to experience certain adverse actions, it's on you as the speaker to prove that whatever adverse actions are as a result of you expressing your activity, which can be tricky under certain circumstances. The tricky thing with a lot of these free speech disputes is that it's highly, highly contextual. It depends on the facts. It depends on who they're saying it to, where they're saying it. All of that is relevant to this inquiry whenever there's a dispute. Also, stop me anytime with questions. Okay. Okay. So I think you get the general gist of free speech. It's very broad, but there are certain categories of speech that are not free speech, and you should have no expectation of being able to say certain things. This kind of takes us a little bit outside of the student in a university context, but I feel like I would be remiss if I didn't mention it. So let's talk about it. These are the categories of speech that are not free. You cannot engage in incitement, defamation, fraud, obscenity, child pornography, fighting words, and threats. So threats is a big one. So I mentioned earlier, anytime that there's allegations of bullying, harassment, or threatening conduct, that's something where the university can scrutinize and punish wherever applicable. So terroristic threatening is a statute here in Hawaii that could be applied to student conduct. That's something to be aware of. Fraud is another one. I have some examples of current events that were very splashy in the news. So there was a CEO of a crypto empire. His name was Sam Bankman-Fried, and he was convicted of fraud, financial fraud. So the speech that he engaged in is he lied to a lot of investors with deep pockets to induce them to invest in his crypto empire. And so those lies that he told, that was the basis for his conviction. And then Alex Jones, he got hit with a massive defamation lawsuit. And so what Alex Jones was doing, he had a podcast, a show called InfoWars, and he was, to all his large following, he was sharing his beliefs that what happened at Sandy Hook was a hoax. And the statements that he made had really horrible consequences for the parents who lost children during the Sandy Hook massacre. And so for years he was able to get on his radio show and say all sorts of horrible things about paid actors and how all of that bloodshed never really happened. And eventually he got hit with a defamation lawsuit. So you can try to argue that it was free speech, but at a certain point, those kinds of consequences will arise. Then you also have, I think, child pornography is sort of self-explanatory, incitement and fighting words. So incitement, the general idea around incitement is when you engage in speech that causes people to engage in illegal activity. That's something that is not allowed under the First Amendment. And then fighting words, that's a very, very old concept coming from case law. There's a case, so the picture on the bottom right, there was a gentleman way back in the day. He was a Jehovah's Witness, and he was distributing literature, sort of promulgating his ideas as a Jehovah's Witness, and a lot of that was insulting to other more mainstream religions. people complained, the town marshal stepped in, and Walter Chaplinsky is his name. He ended up getting arrested for, causing all sorts of disruption with his speech, with him passing this literature. He turned to the Grand Marshal, the law, and called the officer a goddamn racketeer and a damn fascist. And the court determined that those were fighting words, and they were not allowed under the First Amendment. They caused a direct harm to their target, that being the law enforcement officer, and could be construed to advocate an immediate breach of the peace. Thus, they lacked the social value of disseminating ideas to the public that lay behind the rights granted by the First Amendment. So that's a very old concept. You don't really see those kinds of claims these days when it comes to fighting words, but that's the whole idea with fighting words, is it's the kind of animating language. As soon as you utter it, people break out in pandemonium. That's the sort of idea. So that's speech that is not free.
Here, there's a question.
Yeah.
So was the fact that he called him a fascist, or was it the foul language, or was it the combination? Like, or is it just the argument that the officer felt bad?
So it's not the foul language. So like saying those dirty 4-letter words, that's free speech. That is protected. But in that day and age, in that context, calling somebody a fascist was very, very incendiary.
So it's contextual in time.
Exactly.
Taylor,
Yes.
burning of a draft card, is that under fighting words or incitement?
Are you asking me because you know the answer already?
No, I don't remember, so I'm asking you.
Yeah, I'm not too familiar.
I think that was a national security issue.
Yeah.
For identification, yeah.
Infringement on freedom of speech because it was for national security. It got passed.
Thank you, Yvette. Thank you, law student.
I thought it was because it was for identification purposes by the government as well.
Okay, so for your edification, I think terroristic threatening would be the one that you'd want to pay attention to in this context. So I looked at the statute for terroristic threatening in Hawaii, and the elements of that are as follows. So if you threaten by word or conduct to cause bodily injury to another person or serious damage or harm to property, including the pets or livestock of another, to commit a felony with the intent to terrorize or in reckless disregard of the risk of terrorizing another person, or with intent to cause evacuation of a building, place of assembly, or facility of public transportation. So a big part of terroristic threatening is they have to prove that you had the intent to terrorize another person and to influence their behavior. Okay. So I always have to remind myself, I was big into international law, and hate speech is a concept in a lot of other countries, but it's not in the United States. Right. Right. Hate speech is permitted under the First Amendment. So looking at old case law, justices in the Supreme Court, they would say things like, the First Amendment is a broad guarantee of freedom for the thought that we hate. Yeah. There's this quote, I forget who said it, but I may not like what you say, but I'll fight for your right to say it. So that's something that's very American, is the most offensive, the most odious things that you can think to say. We don't want to allow the government to punish it. And another old case back in the day, there was a justice who said, whenever there's this kind of speech that's being circulated, the remedy to be applied is more speech. So the whole idea is there's certain ideas, there's certain expressions that are offensive, they're ugly, but we don't want to prohibit it, we just want to encourage more speech to drown out the hatefulness. That's the idea. So, when we talk about speech outside of campus, that opens up a whole lot of possibilities that were not originally sort of thought of in the original case law. The internet is a very, very powerful tool. When people are users on the internet, they tend to get very bold and brash and say things that they would never say in person, and the ability to reach a wide audience, it's very, very powerful. For those reasons, whenever there's a conflict, a lot of times social media is involved. So I wanted to spend some time sort of digging into the specifics of that and what that looks like. And again, as I mentioned, you will see universities struggling to balance the rights of free speech along with protecting marginalized groups and also imposing restrictions that are reasonable, right? Also, the internet is forever. You know, you post something and it's there, right? And so that's another thing that gets people in trouble is you'd like to think that the thing you posted years and years ago doesn't matter, but it's there and people can look it up as if it happened yesterday. And yeah, for better or worse, that's what leads to a lot of conflict. Okay, so let's go back to the year 2017. We're at a public high school in Pennsylvania. There was a high school freshman and she was having a really bad year. She wanted to join the varsity team, but she didn't make it. And she was really hoping to get a certain position on the softball team, but she didn't get that position. She was really, really fed up and she wanted her Snapchat followers to know. So she got on Snapchat, she brandished her middle finger and she said, fuck everything. Fuck the school, fuck softball, fuck cheer, fuck everything. And it caused a lawsuit at the Supreme Court. You would think it's Snapchat, you know, it's just a brief moment in time, right? For those of you who don't know, you put it on Snapchat, within 24 hours the message is gone. But what happened in this particular case is another cheerleader saw it, she took a snapshot and sent it to the cheerleading coach, right?
Well, they just suspend her?
Okay. So, as a result of that conduct taking place on Snapchat, the school caught wind of it and they suspended her from the junior varsity team. And the basis for that suspension was that she had violated the code of conduct. All cheerleaders at that school, they must agree to show respect for their teammates, coaches in the school, teachers, and other schools' cheerleaders. The school's code of conduct also forbade the use of profanity, and another rule forbade cheerleaders from posting negative information about cheerleading, cheerleaders, or coaches on the internet. Okay. So, the student was punished, and as a result, she and her parents filed a lawsuit in the school for violation of her First Amendment rights. A couple things to keep in mind. This is the high school context, so it is different from the university context, and the Supreme Court acknowledges that. Another thing to note is that if she was an adult, there's no doubt about it that that was free speech, right? But because she is a minor, because the school has certain abilities to regulate speech within the schoolhouse doors, it creates this question of what happens when a student goes off campus and does something that they're not allowed to do on school, but everybody at school knows about it and they're talking about it. What is the school to do? So when the Supreme Court looked at this case, they ultimately came out with a very, very narrow decision. They said that the high school violated their students' First Amendment right to free speech by punishing her expressive conduct on Snapchat. So they pointed out that the students' criticism of the school was pure speech and was absolutely protected by the First Amendment. So what do I mean by pure speech? The post itself did not target an individual member of the school community with vulgar or abusive language, which diminished the school's interest in punishing her. While acknowledging the school's interest in punishing vulgar speech, it found this interest outweighed by the fact that the student spoke outside school on her own time in a location where the school wouldn't ordinarily act in loco parentis. So that's the idea that schools get to step in as parents when parents are not around, when it comes to the care and custody of minors. But when the student is on their own time, that's the parent's realm. And so the school is not able to step in that particular circumstance. Also, the court made note that the post caused no substantial disruption beyond 5 to 10 minutes of discussion in one classroom over a few days, and that the post did not seriously impact team morale. So the court is looking at all of those factors to say, yeah, it probably wasn't a good idea for her to do that, but there's no legitimate reason for the school to step in and punish her when she's doing this on her own time. It's important to note that the court further elaborated a couple of things. They said that schools can regulate off-campus speech, but only under certain circumstances. And what they said those circumstances looked like. It looks like serious or severe bullying or harassment targeting particular individuals. It also looks like threats aimed at teachers or other students, the failure to follow rules concerning lessons, the writing of papers, the use of computers, or participation in other online school activities, and breaches of school security devices. So the Supreme Court did not want to say that the school could never look at social media and activity on the internet, but they elaborated certain specific circumstances where it would be justified for a school to step in and say, hey, that's not allowed. These are not circumstances where we're looking at pure speech, right? This is not the circumstance where the student is bashing the school. This is a circumstance where the student is engaged in speech activities that infringe upon the rights of others, that cause, a substantial disruption to what's happening inside the school. And if they're breaking rules, if they're plagiarizing, if they're sort of breaking security protocol for technology devices, those are all things that the school can regulate and should regulate, but pure speech is not one of them. Also, as I mentioned, one of the justices in his concurrence, he wrote that this particular decision is not meant to apply to university students. He acknowledged that when you're talking about university students, they have a different age, their level of independence is different, and they're in different living arrangements. So for all those reasons, the decision in this case cannot be directly applied to the university context. It does give us some hints on how the Supreme Court would decide such a case, and I'll talk about that. So that's what happened in this situation. And that decision came out in 2021, so it's still pretty new. Okay, so I was once a student at the University of Mississippi, and so I'm familiar with this incident that took place. So let's pretend it's 2016 and we're at the University of Mississippi. At this time, there's a lot of Black Lives Matter protests happening all around the country. In North Carolina, there was a black man by the name of Keith Lamont Scott. He was shot by the police and died as a result. And this gave rise to a lot of days and nights of protesting, very vigorous protesting, and it was covered very widely in the news. In response to that news coverage, you had a young white man, student at the University of Mississippi. He got on Facebook and said the following: I have a tree with enough room for all of them if you want to settle this Wild West style. All right, so you may not know, maybe you do, he's referring to this ugly legacy of lynching. And in particular at the University of Mississippi, it's an old university. It's been in existence since before the Civil War. So they have a long, very ugly history with all kinds of bigotry, in particular racism. So when he said this on Facebook, it touched a nerve. And even in those days in 2016, every semester you would get news stories of students saying very wild, very ugly, nasty things. So this was one of a long series of mishaps. So when he said this, it was reported in the news. It made the school look terrible. It spread far and wide. The chancellor quickly issued a statement saying that the school didn't condone this kind of statement. Do you think the school punished him? What do you think?
No.
The chancellor said, "We don't condone this statement." The very next day, he had a whole group of protesters. So this is outside. The Lyceum is the building that houses the administrative offices. That's where the chancellor stays. I don't have a picture of it, but just imagine inside the building, right outside his office, you've got a whole lot of students lining both sides of the hallway. As I mentioned, this was one of a long series of mishaps, and people were ready for the next one. So when the chancellor said, "We don't condone it," the students stood up and said, "Wait a second." So the University of Mississippi has this creed that they spent a lot of time lavishing praise and positive attention. They're trying to sort of rebrand themselves, distance themselves from this racist past. And so every year we would have an entire week dedicated to the creed, and anytime there would be these ugly incidents, the administration would point to the creed as if to say, what that student did doesn't represent us, we adhere to the creed. So when that incident happened, all those students stormed the Lyceum and they said to the chancellor, "It's not enough that you refuse to condone this student's statement. If you really stand by this creed, if you mean what you say, you will take action against the student." They pointed out, and rightfully so, it's not very civil to threaten to lynch a group of people for exercising their First Amendment right, and it's not very respectful of their dignity, right? So they had a point, right? But the university, as I mentioned, they're in a tight spot because, the student is saying this offensive stuff, but there is no way to punish hate speech under the law, right? But what are you gonna do? You have all these students and they're demanding you take action. So what happened at this time in 2016, there was a closed door meeting between the chancellor and the student who made the Facebook post. And as a result of that meeting, the student agreed that it would be best that he voluntarily withdraw from the university. Okay, so this was what was reported in the news at the time. Even though the social media comment he made may have been protected expression, he wanted to take responsibility for the impact of his post on our community. So that's how they threaded that line.
Wow.
Also, there were certain sort of organizations and programs on the campus, very well funded. So these are entities that deal with racial reconciliation work, and the student agreed, even though he wasn't a student taking classes, he was going to stay on the campus and work with racial reconciliation groups to develop a plan that will provide him with learning opportunities and restorative justice activities. So my point with this example is there might be times where the First Amendment laws are a hindrance, or they're not giving the result that you might want to see. There's still sort of pressure that can be applied, and that's what it would look like, is enough pressure to get the university to take some kind of action, even though it's not a formal reprimand. They were able to ask the student to remove himself in accordance with the creed. Does anybody have any questions? Okay.
Phil, do you know, like, how the restorative justice process worked, and just out of curiosity?
I don't know the specifics of the plan that that was implemented. I did look him up. 4 years later, he did graduate from the University of Mississippi. He works at a bank now. So, it's 2024 at the University of Hawaii. Now, there's a big part of all of this that I haven't mentioned to you. So, we talk about codes of conduct in the high school context, and then also at the University of Mississippi. You here at the University of Hawaii also have, aside from your free speech policy, you also have policies that look at student conduct, that govern non-discrimination against protected classes, and also governs sex and gender-based misconduct. There is a lot in these policies. Honestly, I don't feel like I'm the best person to speak to all the nitty-gritty details of them, but I do want to bring them to your attention because these policies are far-reaching, and they enable the university to look at conduct that you engage in outside of campus, in particular social media, right? So I do want to take a look at that. So one thing to keep in mind, if it's a situation where the university is looking at your social media conduct, there's a couple things that have triggered that. So if the conduct was in connection with a university-sponsored program or activity, and the conduct may have a continuing adverse effect or could create a hostile environment on campus, that would allow the senior student affairs officer to decide on a case-by-case basis whether or not they could punish you under these policies. So that's one thing to note when you're on social media, is that the school would likely step in if it's such a disruption, if it causes a hostile environment. Okay. So, system-wide student conduct code. It's very long, it's very legalistic. Honestly, kind of confusing. But certain things that you should know. Again, they want to prohibit disruption or obstruction of teaching, research, administration, disciplinary proceedings, or other UH activities, including its public service functions on or off campus. It's also a policy that prohibits any conduct that threatens or endangers the health or safety of any person, including but not limited to physical abuse, verbal abuse, threats, intimidation, harassment, bullying, coercion, and stalking. One thing to note, when we talk about harassment in the legal sense, harassment is something that is severe, and it's pervasive, and it's objectively offensive. So they're looking for conducts that is repeated and it's severe. So that's one thing to keep in mind, is you can be on social media and engage in conduct where there is a victim who has said, I've been harassed. And that under this policy, the university is allowed to scrutinize that and punish it where applicable. There's also a policy that deals with non-discrimination against protected classes. There's a long list of protected classes, talking about race, sex, gender identity and gender expression, age, religion, color, national origin, ancestry, citizenship, disability, genetic information, marital status, pregnancy, and all pregnancy-related conditions, including breastfeeding, arrest and court record, sexual orientation, National Guard participation status, status as a protected veteran or other military status, status as a domestic or sexual violence victim, or any other protected category under federal or state laws. and or executive orders. It's very broad. But that's one thing to keep in mind when you're engaged in speech that touches upon any of those protected classes. That's where this policy would apply. And so specifically, under the policy, they prohibit harassment. And again, harassment is severe, it's persistent or pervasive, and it unreasonably interferes with the student's academic performance or the employee's work performance, or it creates an intimidating, hostile, or offensive or work or educational environment. And then, last but not least, is the sex and gender-based misconduct policy. I think this is the longest of the policies, and it is very, very broad. Couple things to note. Both the non-discrimination and the sex and gender-based misconduct, those have been recently updated. So as recent as February 2023, these policies were updated and had pretty significant policy changes. Of note, in the sex and gender-based misconduct policy, it covers the usual prohibited behaviors: sexual harassment, sexual discrimination, sexual exploitation, stalking, retaliation. But it also includes prohibition against sex-based and gender-based harassment. Those are slightly different things. So sexual harassment is something that involves trying to induce sexual favors from a person, right? But if you are engaging in sex-based harassment, you're looking at a person's biological sex or their gender, right? And you're discriminating against a person based on the sex that you believe they have or their gender expression. And that's something that wasn't contemplated in earlier versions of the rules. Also, under the title, I'm going to call this the Title IX policy. Under the Title IX policy, they lowered the standard. So if there is a dispute and the university is investigating whether or not punishment applies, the standard that they would have to prove is lower. It's a preponderance of the evidence standard, which is much, much lower. So that's one thing to keep in note. Any questions? Yes.
So, going back to the last slide, you were talking about how it's about persistence and happening time and time again. So that example you gave, University of Mississippi, if, say, they went back on social media and there was like just a series of posts going in the same direction over
Mhm.
the years,
Mm-hmm.
would that have been with more of a case to build an actual policy action against them?
I think so. I think so. Yeah, that specific instance, it was definitely offensive. It was targeted at people that were not part of the university community, and it was only that one time, right? So those are all things that would make the university very, very hesitant to step in a big way. But you're right, if the nature of the speech was a little bit different, that would change. I mentioned that a lot of these policies here at the University of Hawaii changed pretty substantively in the recent years, and there's a reason for that. So, you were all here for the Me Too era, yeah?
Mm-hmm.
You were all here for the culture wars. So a lot of this is dependent on who's sitting in the White House. So during the Obama administration, they took a good look at the Title IX protections, and in an effort to be more protective to victims of sexual assault, sexual misconduct, they implemented certain policies that sort of broaden the definitions of what constitutes misconduct, and they sort of went around certain due process protections that would normally be given to somebody who's accused of a crime or any kind of misconduct. And it's a sort of pendulum swing, right? That was during the Obama era, and it was all about protecting victims. But then when Trump took office, there was a rollback of a lot of those protections, and those policies looked very different, right? It was all about making sure that whoever's accused has all the fullest amount of protections that the law can provide, and all of that. Now that President Biden is in office, we see him trying to revert back to the Obama era protections and then some. So that's how you have your sex-based discrimination policies and your gender-based discrimination policies. It is very likely, that the state of the law could change dramatically in just a year or two. When I was in law school, that was in 2019, the policies didn't look like the way they do now, right? So that's one thing to keep in mind, is that when it comes to and non-discrimination policies and things of that nature, what constitutes sexual misconduct, the legal landscape is shifting. So that's one thing to keep in mind. I got this little snippet from the U.S. Department of Education. They have this blog, and so this is them sort of championing under the Biden-Harris administration, that they're trying to promote protections for victims who experience sexual harassment and assault at school, and also people who identify as LGBTQI students. They want to make sure that there's maximum protections for them under Title IX policies. You will have some people say that the policies as currently written are horrible for First Amendment rights. And so on that particular issue, the pendulum, you will see it continue to swing. Okay, we're finishing up here. So, as I mentioned, a lot of this is highly, highly fact specific. So if you're in a situation and you think that your rights might be violated, first thing you want to consult the codes, the codes of conduct, the policies that we mentioned. You want to take a really good look at those, and you also want to document everything you've said, everything that was said to you. You need to be able to capture the full factual circumstances around your exercise of free speech in order to get the help that you want. And then the next best thing, if after consulting the policies and you've gathered all your evidence, you want to try to find an attorney, to consult with an attorney. So that concludes my presentation. I imagine you might have a lot of questions. I hope that I helped your understanding of this topic, as complicated as it may be at times. So thank you so much.